Mr. McCabe, I'm puzzled by your refusal to answer Senator Heinrich's question about a conversation you may have had with Director Comey. What's the basis of your refusal to answer that question?
Sir, as I stated, I think first, I can't sit here and tell you whether or not that those conversations that you're referring to.
Why not? Do you not remember them?
No, I'm sorry, sir. I don't know whether conversations along the lines that you have described fall within the purview of what the special counsel is now investigating.
Is there some prohibition in the law that I'm not familiar with that you can't discuss an item and that you've been asked directly a question?
It would not be appropriate for me, sir, to discuss issues that are potentially within the purview of the special counsel's investigation.
And that's the basis of your refusal to answer this question?
Yes, sir. And that, and knowing, of course, that Director Comey will be sitting behind this table
it's your
tomorrow.
position that the special counsel is entitled to ask you questions about this, but not an oversight committee of the United States Congress?
It is my position that I have to be particularly careful about not stepping into the special counsel's lane, as they have now been authorized by the Department of Justice.
I don't understand why the special
to
counsel's
investigate
lane
those
takes
matters.
precedence over the lane of the United States Congress and an investigative and oversight committee. Can you explain that distinction? Why does the special counsel get deference and not this committee?
Sir, I'd be happy
Is there
to.
some legal basis for that distinction?
I would be happy to take that matter back to discuss it more fully with my general counsel and with the department, but right now that's the.
On the record, I would like a legal justification for your refusal to answer the question today, because I think it's a straightforward question.
Mm-hmm.
It's not involving discussions with the President. It's involving discussions with Mr. Comey. The gentleman, Mr. Director Coates and Admiral Rogers, I think you testified, Admiral Rogers, that you did discuss today's testimony with someone in the White House?
I said I asked, did the White House intend to evoke executive privileges associated with any interactions between myself and the President of the United States?
And what was the answer to that question?
To be honest, I didn't get a definitive answer, and both myself and the DNI are still talking to the White House.
So then I'll ask
General
both
Counsel.
of you the same question. Why are you not answering these questions? Is there an invocation by the President of the United States of executive privilege? Is there or not?
Not that I'm aware of.
Then why are you not answering
Because
our
I feel
questions?
it is inappropriate, Senator.
What you feel isn't relevant, Admiral. What you feel isn't the answer. The answer is, why are you not answering the questions? Is it an invocation of executive privilege? If there is, then let's know about it. If there isn't, answer the questions.
I stand by the comments I've made. I'm not interested in repeating myself, sir. And I don't mean that in a contentious way.
Well, I do mean it in a
Yes,
contentious
sir.
way. I don't understand why you're not answering our questions. You can't. When you were confirmed before the Armed Services Committee, you took an oath. Do you solemnly swear to give the committee the truth, the full truth, and nothing but the truth? So help you God. You answered yes to that.
And I've also answered that those conversations were classified, and it is not appropriate in an open forum to discuss those classified conversations.
What is classified about a conversation involving whether or not you should intervene in the FBI investigation?
Sir, I stand by my previous comments.
Mr. Coates, same series of questions. What's the basis for your refusal to answer these questions today?
The basis is what I've previously explained. I do not believe it is appropriate for me to.
What's the basis? I'm not satisfied with I do not believe it is appropriate or I do not feel I should answer. I want to understand a legal basis. You swore that oath to tell us the truth, the whole truth and nothing but the truth, and today you are refusing to do so. What is the legal basis for your refusal to testify to this committee?
I'm not sure I have a legal basis, but I'm more than willing to sit before this committee and during its investigative process in a closed session and answer your questions.
Well, we're going to be having a closed session in a few hours. Do you commit to me that you're going to answer these questions in a direct and unencumbered way?
Well, that closed session you're going to have in a few hours involves the staff going over the technicalities of a number of these issues and doesn't involve us. But
well, is it your testimony that when you are before this committee in a closed session, you will answer these questions directly and unequivocally and without hesitation?
I plan to do that, but I do have to work through the legal counsel at the White House relative to whether or not they're going to exercise executive.
Admiral Rogers, will you answer these questions in a closed session?
I likewise respond as the DNI has. I certainly hope that that is what happens. I believe that's the appropriate thing. But I do have to acknowledge because of the sensitive nature and the executive privilege aspects of this, I need to be talking to the general counsel in the White House. I hope we come to a position where we can have this dialogue. I welcome that dialogue, sir.
I hope so, too. And I would just add, in conclusion, that both of you testified you had never been pressured under 3 years. I would argue that you have waived executive privilege by, in effect, testifying as to something that didn't happen. And I believe you opened the door to these questions. And it is my belief that you are inappropriately refusing to answer these questions today. Thank you, Mr. Chairman.
Before I turn to Senator Lankford, let me say that the Vice Chairman and I have had conversations with Acting Attorney General Rosenstein when a special counsel was named. And as I had shared with the members of this committee prior to that, that as we carried out an investigation, there would come a point in time either with an investigation that was currently ongoing at the FBI, or if there was a special counsel with the special counsel, where there would be avenues that this committee could not explore. And it was my hope that already the Vice Chair and I would have had that conversation with the special counsel. We have not. We've made the request. We intend to have it. And I think that both of us anticipated that we would reach this point at some point in the investigation. We are there where there are some things that will fall into the special counsel and or an active investigation, Vice Chairman.
Let me just say, though, that at this point, we've not had that conversation with Mr. Mueller. We've not been waived off on any subject. And the way I'm hearing all of you gentlemen is that Mr. Mueller has not waived you off from answering any of these questions. Is that correct?
I've had no conversations with Mr. Mueller. I've been out of the country for the last 9 days, and I haven't had an opportunity.
Have any of you
to talk to him.
had, because if you've not had questions waived off with Mr. Mueller, I think, frankly, and I understand your commitment to the administration, but that Senator King, Senator Heinrich, and my questions deserve answers, and at some point the American public deserves full answers.
I'm going to ask Mr. Rosenstein to address that.
Thank you, Mr. Chairman, and I'm sensitive to your desire to keep our answers brief, and my full answer actually would be very lengthy. But my brief answer, from my perspective with the Department of Justice, and I've been there for 27 years, and Mr. McCabe also is a career employee of the Department of Justice, our default position is that when there's a Justice Department investigation, we do not discuss it publicly. That's our default rule, so nobody needs to.
Is that the rule for the President of the United States as well?
I don't know what.
Because that is what the questions are being asked about. Reports that nobody has laid to rest here, that the President of the United States has intervened directly in an ongoing FBI investigation, and we've gotten no answer from any of you. And frankly, we've at least heard from Director Coates and Admiral Rogers that they've not been asked to recuse an answer because of Director Mueller. And I don't understand why we can't get that answer.
So I'm not answering for Director Rogers or Director Coates. I'm answering for Director McCabe and myself with regard to the Department of Justice.
You, it appears, felt free to discuss the conversations you've had with the President in January about Russian active measures. Can you share with this committee how you're determining which conversations you can share and which you don't feel free to share?
Ma'am, the fact that we briefed the President previously, both went up to New York, and previously is a matter of public record.
So if it's a matter of public record, then you feel free to discuss those conversations?
If it's not classified, you can keep trying to trip me up. Senator, if you could I get to respond, please, ma'am?
No, sir. No.
Okay.
Are you saying that if it is classified, you will not discuss it? And then my follow-up question obviously would be, do you believe that discussion of Russian active measures is not the subject of classified information?
I stand by my previous comments.
Thank you. Mr. Rosenstein, when you appointed a special counsel on May 17th, you stated, quote, based upon the unique circumstances, the public interest requires me to place this investigation under the authority of a person who exercises a degree of independence from the normal chain of command. The order you issued along with that statement provides that 28 CFR 600.4 through 10 were applicable. Those are otherwise known as the special counsel regulations. Is that correct?
Yes, Senator.
And it states that the special counsel, quote, shall not be subject to the day-to-day supervision of any official of the department. However, the regulations permit you, as acting Attorney General for this matter, to override Director Mueller's investigative and prosecutorial decisions under specified circumstances. Is that correct?
Yes, Senator.
And it also provides that you may fire or remove Director Mueller under specified circumstances. Is that correct?
Yes.
And you indicated in your statement that you chose a person who exercises a degree of independence, not full independence from the normal chain of command. So my question is this. In December of 2003, then Attorney General John Ashcroft recused himself from the investigation into the leak that led to the disclosure of Valerie Plame's identity as a CIA officer. The acting Attorney General at the time was Jim Comey. He appointed a special counsel, Patrick Fitzgerald, to take over the matter. In a letter dated December 30th of 2003, Mr. Comey wrote the following to Mr. Fitzgerald, quote, I direct you to exercise the authority as special counsel independent of the supervision or control of any officer of the department. In a subsequent letter, dated February 6, 2004, Mr. Comey wrote to clarify the earlier letter, stating that his delegation of authority to Mr. Fitzgerald was, quote, plenary. Moreover, it said that my, quote, conferral on you of the title of special counsel in this matter should not be misunderstood to suggest that your position and authorities are defined or limited by 28 CFR Part 600. Those are the special counsel regulations we discussed. So, would you agree, Mr. Rosenstein, to provide a letter to Director Mueller, similarly, providing that Director Mueller has the authority as special counsel, quote, independent of the supervision or control of any officer of the department, and ensure that Director Mueller has the authority that is plenary and not, quote, defined or limited by the special counsel regulations?
Well, Senator, I'm very sensitive about time, and I'd like to have a very lengthy conversation and explain that all to you. I tried to do that.
Can you give me a yes or no answer,
in the
please?
closed briefing. Well, it's not a short answer, Senator. The answer
It is either you are willing to do that or not, as we have precedent in that regard.
But
Chairman, they should be allowed to answer the question.
It's a long question you pose, Senator, and I fully appreciate the import of your question, and I'll get to the answer. My quibble with you is Pat Fitzgerald is a very principled, very independent person. I have a lot of respect for him. Pat Fitzgerald could have been fired by the President because he was a United States attorney. Robert Mueller cannot, because he's protected by those special counsel regulations. So although it's theoretically true that there are circumstances where he could be removed by the acting Attorney General, which for this case at this time is me, your assurance of his independence is Robert Mueller's integrity and Andy McCabe's integrity and my integrity and those regulations.
Sir, if I may, the greater assurance is not that you and I believe in Director Mueller's integrity, which I have no question about Mr. Mueller's integrity. It is that you would put in writing an indication based on your authority as the acting Attorney General that he has full independence in regards to the investigations that are before him. Are you willing or are you not willing to give him the authority to be fully independent of your ability statutorily and legally to fire him?
He has the
Yes or no, sir?
He has the full independence that is authorized by those regulations. And
Are
Senator,
you
as I
willing to
said,
do as has been done before?
With the senator suspend, the chair is going to exercise its right to allow the witnesses to answer the question, and the committee is on notice to provide the witnesses the courtesy, which has not been extended all the way across, extend the courtesy for questions to get answered.
Mr. Chairman, respectmr.
Mr. Rosenstein,
I would point out
will you-
that this witness has joked with the, as we all have,
The
his
senator will
ability to
suspend.
filibuster.
Mr. Rosenstein, would you like to thoroughly answer
Thank
the
you, Mr.
question?
Chairman. Senator, I'm not joking. The truth is, I have a lot of experience with these issues, and I could speak to you for a very long time about it, and I'm sympathetic. I appreciate the 5-minute limit. That's not my limit. But the answer is, this originated, as you may know, with the independent counsel statute. And I worked for an independent counsel, and I worked in the department during the independent counsel era when independent counsels were appointed by authorization of the Senate. They were appointed by federal judges, and they had essentially the authority equivalent to the Attorney General. That statute sunsetted, and the majority of members of this body concluded that that was appropriate because they did not want independent counsels who were 100% independent of the Department of Justice. That was a determination made by the legislature. Now, I know the folks at the department who drafted this regulation under Janet Reno, and they drafted it to deal with this type of circumstance. And the idea was that there would be some circumstances where, because of unusual events, it was appropriate to appoint somebody from outside the department, not somebody like Pat Fitzgerald, who was a U.S. attorney who could be fired, but somebody from outside the department who could be trusted to conduct this investigation independently and could be given an appropriate degree of independence. Under the regulation, he has, I believe, adequate authority to conduct this investigation. And your ultimate check, Senator, is, number one, the integrity of the people involved in the investigation, but number two, the fact that if he were overruled or if he were fired, we would be required under the regulation to report to the Congress. And so I believe that's an appropriate check. And so while I realize that theoretically anybody could be fired, and so there's a potential for undermining an investigation, I am confident, Senator, that Director Mueller, Mr. McCabe, and I, and anybody else who may feel